So this is the time when it gets real, when you get to rail against us lawyers and news prevention units, as our standards and practices group was pejoratively called at ABC during combative times. I'm really thrilled to be here. The last time I was here, I was talking about a film I did called Trapped, about abortion clinics in the Deep South, and to which Lowell lamented the lack of journalistic standards in documentary. So I believe that inviting a former lawyer who defended newspapers and journalists, and a standards and practices person who would vet these stories is Lowell's sense of humor, and in bringing these journalists who have risked so much and have contributed so much with their work. And of course, the Reporters Committee for Freedom of the Press, which is, I'm sure you all know about the Reporters Committee work, but I think we all owe a great debt to the existence of the committee. So really good panel. Please think about your questions. I thought what we would do is have each of the two journalists give an abbreviated sense, and I can talk you through things, but an abbreviated sense of two of your experiences with publishing the Roy Price investigation, and then we're publishing with answering the subpoena in the Laquan McDonald situation. But then I do want to push you on, kind of what are our obligations as journalists in order to satisfy those who are pushing back against publishing, so that we have that conversation. And also, I would love us to discuss, have our own journalistic standards, I'm going to switch sides so many times here, so try and keep up. But have journalistic, have the standards of journalists shifted? Have the obligations, are people asking more of us, and is that legitimate or not? Is that a fear-based response or legitimately pushing good journalism? So we have a perfect panel for this. Kim Masters is editor-at-large of Hollywood Reporter. You may have heard of that. And host of KCRW's The Business, former correspondent for NPR. She also has served as a contributing editor at Vanity Fair, Time, and Esquire, and was a staff reporter for The Washington Post. I'm going to... Masters was named Print Journalist of the Year by the Los Angeles Press Club in 2012, and as Distinguished Journalist by the Los Angeles chapter of SPJ in 2017. The Business received Gracie Awards for Outstanding Talk Show in 2012 and 2014. So please welcome Kim. You are welcomed. Jamie Calvin is the author of Working with Available Light, A Family's World After Violence, and editor of A Worthy Tradition, Free Speech in America, by his father, Henry Calvin. He's reported extensively on police abuse in Chicago, was the plaintiff in Calvin v. Chicago, in which the Illinois Appellate Court ruled that police misconduct files are public information. Really crucial ruling, actually. His reporting first brought the police shooting of Laquan McDonald to public attention. He's the recipient of the 2015 George Polk Award for local reporting, and the 2016 Ridenhour Courage Prize, and the 2017 Hillman Prize for web journalism. So would you please welcome Jamie? And last but not least, in fact, last but first, is Katie Townsend of the Reporters Committee for Freedom of the Press. She oversees the litigation work of the Reporters Committee and its attorneys, and represents the Reporters Committee, news organizations, individual journalists, including documentary filmmakers, thank you very much, in court access, freedom of information, and other First Amendment and press freedom matters. So please welcome Katie. So I want to start with Kim and her experience in reporting and then attempting to have published the Roy Price story. So why don't you talk about how the story came to you and give us a little background, because the reporting is important. Like understanding the depth and quality of the reporting, I think, is essential to frame the conversation. So why don't you give us a little bit about that?
Well, I have a colleague at the Hollywood Reporter who is not as, she's not super young, but she's only recently found that she has that instinct for investigative journalism. And she came to me, oh, I'm looking at a picture of Roy Price. She came to me with this tip that there was a guy at Amazon who had been at dinner with one of her sources and just really laid out a very distressing picture of what it was like at Amazon Studios. So she just said, what do I do? And we basically teamed up to start reporting, but it was felt that in terms of, she felt strongly in contacting this original source of the Nile source, that I should be the one to call, because we didn't know these guys, and she's not known, and she said, you call. And it was the right call. He said he wanted to meet in person. We sat for hours. He downloaded a lot. And he told me about various instances, the most striking of which turned out to be, and I can say it now, but this incident with Issa Hackett, who is the daughter of Philip K. Dick, and she produces Man in the High Castle and this anthology. And she was the victim of the most unwelcome advances at Comic-Con in 2015. So we started reporting, and it took a long time. Issa initially gave us a really ambiguous statement. Amazon had done 2 investigations of Roy Price as the head of Amazon Studios. Interestingly, throughout this process, Amazon did not threaten us, but Roy Price immediately did. And in retrospect now, I know that his 2 lawyers, Lisa Bloom and Charles Harder, were Harvey Weinstein's lawyers. They were sort of they were buddies. They were intertwined with each other. So once we really started getting momentum,
This is all happening before.
Months before.
Weinstein.
Yeah, I mean, started like maybe a little, precisely more or less a year ago. Yeah. So we're pressing and pressing on this, and Charles Harder at that time just absolutely unhinged our lawyers. Just the fear was beyond. I've been threatened with many, many, many lawsuits. I've covered the Church of Scientology, many threats. I was just thinking about a little list in my head last night, the fired head of ABC, this one, that one, and the other one. I've never had a story not publish. And those circumstances I've only had 1 lawsuit in my life, so
can I ask you, were you thinking about publishing, did you go to the Hollywood Reporter first?
Yeah, I worked for the Hollywood Reporter, and it became, I don't want to go into too much detail about the machinations at the Reporter, but there was enormous pushback from the lawyers, and at some point I started to speak, I got to the point of saying, I have no confidence in you. I don't want you reviewing this article. I think you're in bad faith. I think you don't want to I kept waiting for this person to say, OK, now you've gone too far.
Right. But tell us what you feel comfortable disclosing. But I want to talk about that, because to me that is remarkable in that you are a very well-known figure and reporter. And this is your own publication. We all know when you've got in-house lawyers and in-house people vetting you, you work with these people all the time.
Right. But there are the good ones who want to help you publish, and to me, the bad ones who obstruct everything.
So were you surprised at the amount of pushback from the lawyers? This was unusual.
It was, we definitely get put through our paces, but in many cases, I hadn't seen this degree. I would call it hysteria. And it wasn't just at the Hollywood Reporter, because I subsequently went to multiple other publications, and there was an environment of absolute hysteria in the wake of Gawker and the Hulk Hogan case.
So did you feel that it was the fact of who the lawyer was, who
Absolutely.
representing?
And they fabricated a story, someone did, about me. They said that I had tried to ask Roy Price for money to underwrite my show at KCRW, which is actually quite malicious, because they could have said I pressured him for ads in the Hollywood Reporter, but they wanted to drag in the 2 places where I work. And the most alarming thing to me, given my resume, which is not bad, is that they would say, well, of course this is at multiple publications, including mine. We don't believe that you ever would do that. I mean, KCRW didn't even get the concept, because that's not really a thing. But I kept having to explain it over and over again, like, no, I think, anyway, they didn't believe it themselves, I'm sure. But they kept saying, we don't believe it, but could you prove that you didn't do it? Like, could you have an exculpatory, like what, an email that says, whatever you do, don't contribute to KCRW, just please. And I thought, they asked me, does your email signature say support public radio? And I'm like, oh, that's the smoking gun? You got me now? It's so ridiculous. Now, I will say to one point that was of concern and is of concern in our profession, I had multiple sources who would not go on the record, and in the initial going, Isa Hackett gave an ambiguous statement. If you could read and add 2 and 2 and get 4, you knew she was confirming the incident, but she didn't quite go. It was like, I will only say, I won't discuss this except that respect in the workplace is paramount, something to that.
But so my question is, all right, she's not going to go on the record. She's not going to be named.
She was named with this ambiguous statement in the early going. Yeah.
And they wouldn't even entertain, I don't want to pin this too much on their process, but to me, if I was, to be honest, if I was reviewing that story and she's not going to go on the record, there's a way that there are facts that you can publish.
Oh yeah, I mean, I had written the piece and I had 6 sources who agreed so it was stipulated that Roy Price was a public figure. Therefore, his attack on me would have to be on 2 actual malice, which is why they fabricated the story, or recklessness, which no. So those 2 things were really not a thing, and my sources all said, we will speak to your editor, we will speak to your lawyer, and we will come forward. They said it in writing. This was an extraordinary demand.
That's
we will come forward and testify truthfully in court if this guy actually sues you. And I'll just say, I knew more than I could publish, as we often do. And if he sued me, it's discovery time. So I'm like, he's not going to sue. And they were just absolutely, everywhere I went, oh, he's going to sue. He's definitely going to sue. It's going to happen. I've never seen anything like it. I thought, this is the end. I really, truly will tell you, it was a nadir of my experience as a reporter. I thought, if this is the environment we have to work in, it's not just chilling, that's freezing. I mean, we were done.
I'm wondering how often the Hollywood Reporter has, most of the coverage is not investigative journalism.
But a lot of it
coverage.
Actually is.
Okay.
I mean, we have relieved John Lasseter of his job, and the financier of June Pictures, which unfortunately made good movies, but this guy was wrong. So we have done. We've done a lot. We've done things about treatment of animals. We've done things on Scientology. Yeah, we have been aggressive. We've done sexual harassment stuff in the past. Where I remember in the early days it was Steve McPherson who had been fired from ABC, but nobody said why. And I was on the phone with our lawyer and Janice Min in the dark of night. And he said, if your back, she had a source also on it was a sexual harassment story. He said, if your back was against the wall, would your source come forward and testify? And Janice said, oh, hell no. And I thought, we're done here. And the lawyer said, okay, and we published. And we were threatened. We had a threat letter in hand, as we did many times. I mean, we had a situation with Tony Blair threatening to sue over a story I did, and our lawyers advised us that under British law, we could lose. And Janice sat there and said, give me the value of our assets in Britain, and it came back, it was like $800,000, and she said, tell him to go ahead and sue. So we were not shy, So that was the background in which suddenly, and I will say, the Hollywood Reporter, in my opinion at this time, we've done the Lasseter story, very parallel situation. No one on the record. It is my position that you can't ask a source to commit professional suicide. It's not fair. And if the source is willing to stand up if there's litigation, which is unlikely to happen, but you never know for sure. I mean, I had lawyers saying to me, well, what if they all show up at court and lie? What if we get a judge who's like listening to Donald Trump, or it gets to a jury and they're listening to the fake news? I mean, this was not normal, okay? Yeah. And it went from being the worst experience of my professional life to one of the best experiences. Because in the wake of Harvey, then you said, I mean, I fought long and hard to get it published somewhere. The Information, which is a tech website, published a sliver behind a paywall.
I mean, how did that feel for you?
It felt horrible. I mean, I want to thank the information.
Do you say, don't publish at all? I mean,
I said, if you don't let me shop this elsewhere, I'm leaving. So that was not a thing that I wanted to. They were like, what? So I shopped it, but I had a hell of a time. I wrote about this in the Columbia Journalism Review. I went to one publication, they vetted it, they indemnified me, they said, we're publishing today, and suddenly the plug got pulled. And I still don't know for sure why, but I think there was a Jeff Bezos phone call to a certain person who owned that publication, I suspect. But whatever happened, I had told my sources, I felt horrible. I said, we're publishing today. More than once I said that. And then I'd have to call back and say, actually, we're not publishing. And I thought they would be like, but you told us. And they were all worried about me. It was sort of touching. They were like, oh, God, you must be, this is so hard for you. Yeah. And you really come to appreciate doing these stories of harassment, how difficult it is for the sources. Yeah. And I really was kind of touched by their concern for the reporter.
Right. So it does have something of a happy ending in that you published at least a version. And then...
Which didn't fully land. It was behind a paywall.
Right.
Janice said to me, tell them to take it out from behind the paywall, and I will get this more traffic than you can even dream of. And they wouldn't, that's not their model, and they wouldn't budge. And they'd only published, I'd say 20% or less of what I wrote. Right. I mean, they had the full thing, but then when Harvey went down, Issa Hackett, I sort of sat there hoping that she would be inspired, because she's a very strong woman. I really admire her. And I knew, the other thing I would say with these witnesses off the record, these sources, you got to feel like they're going to stand up if they're not going to be knocked off their perch in the first round of a deposition. So Issa was like, she actually did talk to a set of editors at a different publication, the one that said it would publish, and they dragged her through the most horrific cross-examination as if she were in a trial herself. Where were you sitting? And where was he sitting? And had you met him? And what did he do then? And it was their lawyer and the two top editors, 3 guys, just interrogating this woman. I felt so sick that actually I felt that they were going to kill it, but I just sent them an email and said, I regret putting her on the phone with you, and I withdraw. I'm withdrawing. You're out. And she will never ever talk to these people. She's so bitter. She was so great in that conversation, but she did stand up when she saw the women coming forward about Harvey. She called and said, "I'm ready to go," and that was it. We published, and he was gone 3 hours later. And they knew about this literally for more than 6 months because they'd investigated him starting in 2015. It was surreal to me that Amazon sat there until the story got as bad as it could possibly get. But go figure.
Go figure. So, advice,
I mean, I think it's changed. We did the Lassiter story, as I said, without a source on the record. And actually, Disney beat us out by about 10 minutes by sending out a memo saying he was being put on leave. I don't think he's coming back. So the environment's changed, and that's the good news. And I just would say, do your homework and make sure you've got it. I didn't put one thing in the Royce Price story initially from the get-go that I didn't think was absolutely nailed. There wasn't something like, I'll see if this can get passed. It's like I knew there was going to be a lot of blowback. And in the Gawker case, there was a billionaire backing the plaintiff, and it looked like Roy Price could also be backed by a billionaire, and that was one of the fears. So, I nailed it down, and all I can say is I can't even give you advice, because if you do what I did, you should be able to publish, but you've got to be backed by your editor. And I did say to a certain editor in the midst of this, there are okay editors and there are great editors, and you're at a place now to show which one you are. And you know what? He didn't publish.
Alrighty then. Jamie, I want to talk about, there's 2 different things we can talk about, but let's talk about Laquan McDonald, because that's a different situation, a different kind of legal jeopardy that you were possibly facing. So why don't you give us some background on what happened before you were subpoenaed?
Right. So I assume the name Laquan McDonald, resonates in this room. It's one of the long list of names that have come to be a kind of shorthand for patterns of racial injustice in the criminal justice system. 16-year-old boy, 17-year-old boy, shot in the late fall of 2014 in Chicago by police officer Jason Van Dyke. The initial story reported in the media and promoted by the Chicago Police Department was aggressive young man with a knife, lunges at officer. Officer has no choice but to defend himself and his fellow officers, shoots him in the chest. He dies sometime later at a nearby hospital. I was aware of the story, but like in my lifetime Chicago, and no doubt thousands of stories I've read in local media, you know, you turn the page. There was really no history or tradition of digging into these stories, absent a whistleblower. And about 10 days after the incident, a whistleblower reached out, somebody in law enforcement, with information that the shooting a couple of weeks ago wasn't at all what it appeared. It was horrific. There's dash cam video in possession of the police department and the agency tasked with investigating police shootings. And he also had not an exact address, but sort of coordinates for finding a civilian witness to the shooting. And I began to report the story, ultimately found the civilian witness who was appalled to have me show up on his doorstep, having just witnessed what, you know, ultimately proved to be an execution by the police, but eventually was very cooperative, gave a precise description of what he'd seen that ultimately was corroborated by the now famous video. The point at which I published was when I was able to access, through a source in the medical examiner's office, the autopsy, or I got the substance of the autopsy, and then the day it was subject to being FOIA'd, I officially got it through FOIA. And the autopsy showed that the young man had been shot 16 times, 16 independent gunshot wounds, front and back. So, you know, it wasn't possible at that juncture to say what in fact had happened that night, but it was possible to completely impeach the official narrative of what had happened. The police story simply couldn't be true. And at that point, I published, this was February, early February 2015, in Slate, a story that had the title 16 Shots. Was
there any hesitation at Slate about
actually,
publishing?
there wasn't. I've done subsequent stories that, and very much like Kim's experience, that relied heavily on whistleblowers within law enforcement. And in my case, you know, extraordinary sources who, just in the nature of being a whistleblower, sort of trying to escape from the code of silence and share information, the limits on how much you can corroborate. So that's another story, which if there's time I'll tell. The Slate piece had considerable impact as an article, and there was actually was subsequently emailed. The city was completely stonewalling, not responding to me or other journalists. Once the Slate piece appeared, every journalism outlet, you know, sought the video and was told not available, it can't be provided because it's an open investigation. But one of the interesting sort of sidelights is while stonewalling, the NBC affiliate in Chicago did a subsequent FOIA request for email traffic within the city. And within, I think it was 13 minutes of the Slate piece being posted, it was in the email box of the mayor's entire senior staff, corporation. So they're sitting on the edge of their seat. Huge energy, immense energy is being invested in maintaining this false narrative, a narrative which they knew was false within hours of the incident. They had the videotape. They had multiple civilian and police witnesses. The autopsy was performed the next morning at 8:30. It takes months for autopsies to be finalized. It doesn't take long to count to 16. And just the machinery of how these stories are managed, the sheer force of the official narrative, and the way in which, to use the imagery of the moment, Black lives are made to disappear, is really a huge part of what this story is about. Ultimately, pressure builds, more and more pressure demands for the video. As probably everybody knows, the video is ultimately released, and then there's a huge cascade of events when people see the corroboration in the video of what had been reported. The superintendent of police is fired, the administrator for the agency that investigates police shootings is fired, DOJ launches an investigation in Chicago. The state's attorney who had not filed charges against the officer is voted out of office. So it had all of these consequences. That's sort of the backdrop for what happened more recently.
And so the police response. So what was the police response to you during this process?
Well, it was good. I mean, I've been in this space reporting for a long time, and actually have police sources and friends in the police department, and many one officers who would spit in my eye if they saw me. So that was, ultimately, one of the more significant things that happened in the immediate, aftermath of the release of the video is the state's attorney charged Officer Jason Van Dyke with first-degree murder.
I mean, a huge, kind of turning point in in how I think also the public viewed police allegations of, because I think that until then, there still was this narrative that, that the police were truthful and would not actually lie and cover up, that was all conspiracy theory nonsense.
Right, and I think what we know now beyond the video, there's rarely been a case we've known more about than this one, because then all sorts of information came out, and it now is definitively known that evidence was destroyed, witnesses were immediately intimidated rather than interrogated, reports were falsified in a coordinated way. So, I mean, I find it useful to think of this dynamic as a matter of sort of power and powerful institutions establishing a narrative, and then having to go to great lengths to sustain it. And one of the things, partly because our mayor in Chicago, Rahm Emanuel, is disliked by many subsets of the population for a wide range of reasons, is the cover-up narrative has been very attractive, particularly in the press, that frame. And I've really pushed back against that consistently, because if that's the diagnosis, then the prescription is, vote him out of office, indict him. The idea of a cover-up of a small group of co-conspirators who know they've done something wrong, compound the harm by covering up. This was the system. This was the machinery. Everybody from officers on the scene who went into a nearby Burger King and commandeered the surveillance equipment, lo and behold, the relevant minutes disappeared from the cameras, including, incidentally, the camera that was focused on the French fries. Just everything disappears. The officer,
why are they bad?
The officers who fabricate, everybody knew their roles. Yeah. The senior detective who comes on the scene supposedly to take charge of the crime scene. I mean, this is sort of novelistic interpretation, but I think it's fair, at least to entertain, comes not to investigate what happened, but to investigate how to justify what happened. And that can actually shape perception. That can actually shape what you see. If that's how and you do it with a sense of vocation, and you're doing it on behalf of an institution you've pledged your life and career to. But that system, ground on and on through this. It was 13 months, I believe, after the incident that the video was finally released. And ultimately, it just completely collapsed. The official narrative collapsed, and we still live in that space in Chicago, where political power, sort of, and the legitimacy of various institutions, kind of cratered. But I am optimistic, but I think there's tremendous suspense about where this goes and where we end up.
Could you talk about the effort to get you to reveal your sources?
Yeah, so this fall, long after, there's been a long pretrial run-up to the trial of Officer Van Dyke, and it's, consistently front-page news sort of from week to week in Chicago. This is the trial in Chicago. And in October, I had actually just come back from Europe, showed up in my office, and was greeted by a subpoena calling for me to appear in less than 24 hours in court. We postponed that just because it was.
And could you clarify? Were you employed by Slate, or were you?
No, I was independent.
Independent,
just
right?
Wrote the piece.
So, as an independent journalist,
Yep.
when you get a subpoena, it's a different situation than if Kim is working for
Right.
Hollywood Reporter, or if someone's working for one of the networks.
Right.
So talk about that.
I've been through this before, so I have some past experience with it, but.
So you didn't freak out.
I did not freak out. I was a bit surprised. I thought that the Laquan McDonald reporting was in the rearview mirror for me, and I am very, very fortunate. And it's one of the things, as I tell this part of the story, to remember that I was just extremely well positioned, have a network of civil rights attorneys who have.
Who are these people?
I don't disclose sources.
Okay. But it's an
no. So I've worked on these police accountability issues for a long time, and actually have seen as part of my journalistic practice an important function being to sue the city.
Right.
So you referred to the Calvin versus Chicago decision on police disciplinary records. So there have been a number of attorneys who worked with me and my colleagues on a pro bono basis. I immediately picked up the phone and called two of them. So I didn't have that panic moment of, oh my God, But it was a very surreal experience. So I was called, and I think it also, like Kim's experience, could have happened at any time, but is of this moment, is of this moment. And the basis for the subpoena was allegations by the defense team for Officer Van Dyke that and I never disclosed the source, who obviously would have faced all sorts of consequences, that the source had given me protected documents under, I'm going to go into details, something called the Garrity principle, that I had then used the knowledge I'd gained from those documents to shape the statements of civilian eyewitnesses who would presumably be significant witnesses in the trial. But the other feature of this was that the judge, who was part of the challenge here, a very imperious judge who cares about quote-unquote decorum in his courtroom, had imposed, in effect, a gag order on the proceedings. So the filings were not public, and it was only when we got into open court in a hearing about 6 weeks into this that people learned what was being alleged. And essentially what was being alleged with no factual basis at all, a complete fake news fabrication, was that I had, from the start, been acting not as a journalist, but as an anti-police sort of activist, had conspired with the FBI, that the FBI had let me into interviews with occurrence witnesses, and that I had conspired with civil rights lawyers representing the family and estate of Laquan McDonald. It went on, and that's why they need
to underwrite your program at KCRW.
That's why they needed to know who for me to reveal the source, and it was hallucinatory. I'm prideful enough as a journalist that I was a little bit loath to dispel the FBI rumor. Calvin's got FBI sources. But it was that wild, and it was all about a narrative which I think we'll see replayed at trial, that essentially the press, that the victim in this case is the police officer, and that the press has created a climate where.
Yeah. I want to ask you, because so that was, what was the date?
That was this fall. I mean, it was resolved in mid-December.
Right.
Yeah.
But you're operating in this era of quote unquote fake news.
Yeah.
And so how do you think that played into, the resolution?
Well, I think that what's disturbing about it, so I should also say I got phenomenal support. Great pro bono lawyers representing me. Katie and the Reporters Committee entered in, early in the process, not at an appellate level, and mobilized 18 major media organizations to support a friend of court brief. As you mentioned, I'd won something called the Hillman Prize last year. The Hillman Prize judges put out a petition of support that was signed by hundreds of people. I got incredible support, but I would not. And the subpoena after a couple of months plus was quashed by the judge. I would not want to suggest that this was a free press victory. And as I said before, I was really well positioned to withstand this for a variety of reasons. Access to quality legal representation. Nobody questioned the public importance of the reporting and the role of the whistleblower. Tremendous sort of civil society support. But there was no basis for the initial issuing of the subpoenas. So imagine, I mean, it's not a precedent in a formal legal sense, but imagine if really the takeaway from this episode is that any reporter who's writing about a pending case could be called, by way of subpoena, could be drawn into that case with as little legal basis as there was for the initial issuing of the subpoena. It doesn't matter if it's ultimately quashed. I mean, think about how harrowing that could be.
The harassment.
But also, imagine reporter, without the resources that I had available, a news organization, a publication like so many that is, trying to make payroll next month. And so I think, one of the things we may talk about in the course of this is, I think one of the concerns that we should all be sort of addressing in this era are the dangers of self-censorship. And I don't mean, in Kim's case is an example, I don't mean it only in the sense of timidity on the part of, there are situations where it's a real question. Do I risk the whole enterprise for this story in a time of economic, distress? But I think we need to have a more, self-censorship is rarely called by its name. It's more often, it's an editorial capacity issue. It's a matter of legal prudence.
I'll chime in and say one of the publications I went to wanted to publish, but every time I moved along, it had been rejected by another publication, and it still carried the legal threat. And their lawyer said, they're a great publication. I thought I would have been very proud, but they couldn't. It was about the money.
Yeah, and I think it's so I think there is a danger of more than a danger of excessive lawyer-driven, hyper vigilance about any possibility of legal exposure. But I think there's some real issues that for all sorts of publications and reporters, and it feels important to build that, to build that discourse within the profession.
There's also a real criticism of the judiciary, and how, one of the I think things that I think is underreported in the Trump administration is, we can all see these big visible changes in politics, but seeing the judges that are being appointed, because that issuing that subpoena really does not meet any legal threshold.
Yeah, so this was a very competent Cook County circuit judge. But what was a striking experience for me is that much of what happened in that courtroom had to do less with the law than with the judge's temperament. He's issued more contempt citations, not specifically against the press, than I think the rest of the Cook County bench. We went to court on the ultimate day when he was going to rule. uncertain whether I would be taken into custody or leave the subpoena.
Taken into custody. That means handcuffs, jail.
Yeah, right there.
Right.
I mean, that was there was among the lawyers that accompanied me was one who knew his way around Cook County Courthouse to try to figure out if there was a strategy to bond me out if that happened. So, you know, when you think about the devolution of the federal bench right now, and folks are being, you know, you're talking
Lifetime
about
appointments.
judicial temperament as well as competence. And,
I want to make sure that at some point we get back to. I want to bring Katie in, but I want to make sure that so please remind me that we get back to how did you cultivate the relationship with this pro bono lawyers, because that could be, I think, really instructive for how do you kind of bulletproof yourself so that this isn't, you know, kind of a career ending. Because I think we're going to just see more subpoenas of independent journalists. So I hope that we can talk about that in addition. So Katie, why don't you talk about the climate from your perspective? What are you seeing in this, you know, era? What are some trends that the Reporters Committee is seeing?
Sure, and before I get to that, I will say that to the extent you're an independent journalist and you receive a subpoena, and you're not in a position like Jamie where you have a pro bono attorney or pro bono attorneys who you've worked with in the past, please call the Reporters Committee. That's one of the things our attorneys do. We've represented independent journalists and successfully quashed subpoenas in the past. So don't freak out.
You can just pick up the phone and say.
Pick up the phone or shoot us an email. Our hotline is 24/7, and we will try to assist you the best way that we can. So don't freak out is my best legal advice, I think, in that scenario. Pointing to what Kim started getting to is whether or not the environment has really changed. And I think it's important to point out at the outset that, you know, wealthy, well-heeled individuals or individuals with power threatening lawsuits against members of the media or actually suing members of the media is nothing new. I mean, I think there are a lot of people in this room who have had experiences with this. You know, Mother Jones was sued by Frank Vandersloot, and they ended up winning back in 2015, but cost them millions of dollars in attorney's fees. Just recently, Sheldon Adelson, in a long-running anti-SLAPP dispute over a story that was published in, it wasn't even a story, it was sort of a petition that was published in 2012 by a group called the National Jewish Democratic Council, finally wrapped up. Again, it wasn't successful. Mr. Adelson is going to have to pay close to $2 million in attorney's fees under under the anti-SLAPP statute. That being said, that's expensive, and those are risky cases. But I think what's changed in the current environment are a few things. I think the Gawker case, the Bolea versus Gawker case that Kim referred to, many of you, I'm sure, are familiar with that case. It is Terry Bolea or Hulk Hogan sued Gawker for publishing a post that contained a snippet of essentially a sex tape. I think less than 15 seconds is my recollection of it. A Florida jury awarded Mr. Bolea $140 million in damages. 25 million of those were punitive damages. That is, by any stretch of the imagination, an incredibly huge invasion of privacy tort jury verdict. The thing that's so troubling, I think, and there was a lot of dispute in the media bar about what the impact of the Gawker suit would be on a moving forward basis. And to be clear, there is no legal precedential impact of it whatsoever. One of the problems with the case is that Gawker actually wasn't able to appeal because of the bond requirements under Florida law. They weren't able to post that bond, and 3 months after the verdict, they were forced to declare bankruptcy and sold off their assets, and eventually, post-bankruptcy, settled with Mr. Bolea. So there is no sort of legal precedent established by the Gawker case, but I think what is really troubling is the non-legal precedent. I think it did strike fear in the hearts of many because it really demonstrated that weaponized litigation can not only inflict harm, it can be fatal. for an organization, particularly an organization like Gawker that wasn't a tiny, independent, nonprofit news organization or small organization without any resources at all. I mean, this was an organization that was represented by fantastic attorneys, and I think that fact alone, even setting aside the sort of salacious type of content of the post itself, because I do think there's a lot of media organizations who would say to you, I would never publish, even that 10 seconds of someone's sex tape. That isn't the kind of thing my organization would do, so I'm not so worried about that type of lawsuit. But I think once it came out that Charles Harder, the same attorney that Kim was referring to, who had sort of orchestrated this lawsuit against Gawker and had orchestrated a number of other lawsuits against Gawker with the financial backing of Peter Thiel, in order really, with the goal in mind to do as much damage and to really take out Gawker, which they were successfully able to do through the Balea lawsuit. I think that really did change the climate. I think that really did make people fearful, and I think that.
But also, I mean, to be fair, the fear is real. I mean, they don't exist, so we all need our publications to exist.
I'm going to chime in again. Gawker, that was an invasion of privacy case. It was not about anything other than a very, in my opinion, not smart decision to publish what was presented in a very specific jurisdiction. So yes, I said to our lawyers over and over again, this is workplace misconduct, it's not a sex tape. Fell on deaf ears.
I think one of the things that's most insidious, at least to me, about the Gawker trial, and I think if you watched that trial as I did, and I think many media lawyers did, but also just many members of the media did kind of throughout, is the way that the plaintiff's attorney, and I think this goes into kind of the current administration and the environment that's been created under the Trump administration, the us against them mentality that the plaintiff's attorneys representing Mr. Balea were really able to capitalize, I think very successfully on. Yeah. I mean, they really did a very excellent job of presenting to this Florida jury and arguing to this Florida jury that this elite media, these elite millennial bloggers who think they're better than you, and look at how snarky they are, and look at how smug they are. That sort of mentality, I think you see echoes of that in the attitude that the President of the United States himself seems to have sometimes towards the news media. And so that, I think, also concerns me, I think, on a moving forward basis. I don't think, I do want to put the Gawker case in perspective. I don't think it's the type of case, as Kim suggests, that you're going to see all the time, the type of verdict you're going to see all the time for a variety of reasons. But at the same time, I do think there are reasons that it is concerning, because I do think it gives a blueprint to very wealthy, very powerful individuals at a minimum as to how to inflict as much damage as possible financially on a news organization, and maybe kill it, but if not kill it, maybe wound it very significantly by using litigation.
Do you think there's something journalists can do to really, it seems to me that we've seeded, an SEED, ED, the landscape with this narrative that is, so the plaintiffs, it seems to me, are 50% there. They believe journalists are snarky and not to be trusted, and they believe it's this elite, there's this kind of agenda out there that people are meeting with George Soros and getting paid to, protest and all of that. Is there something that journalists, maybe we shouldn't have to do it, but is there something that journalists should be doing to address those underlying concerns? Is that, typically we're like, we report, we publish, that's our job. It's not our job to address the social circumstance in which we are reporting. But what do you think? And I'm wondering what you two think about that. Is that something you're willing to take on? Is something you think, I'm not going to take it on and we're going to ride this moment out? What do you think about addressing the climate in which you are working?
So for me, the real issue goes back to the matter of self-censorship in journalism, in terms of what journalists can do and civil society can do more broadly. I think, we heard a brilliant discourse this morning on the current state of the First Amendment at the level of the Supreme Court and in the society more broadly. I think it's, my father was a First Amendment scholar, and after he died, I spent some years working on his last manuscript. It was published under the title A Worthy Tradition. And the idea that the First Amendment is more than a body of law, that it's a tradition of the society that includes the body of law, includes a history, the narrative, the debacles as well as the moments of clarity, the periods of constitutional amnesia as well. And that, especially in a time like this, with the climate you just evoked, with the unbelievably rapid devolution of the federal judiciary right now, thinking about what, beyond just reporting the news, sort of what our vocational responsibilities are under the First Amendment within that tradition is really critical. So, as I said before, my little episode with the subpoena was not a legal victory, but I think it was a kind of civil society victory because of the support from other journalists, and so we have. It's understandable, but I think to a fault, we have a very legalistic way of thinking about freedom of the press and freedom of speech. We think this is something that lawyers, legislators, courts determine the parameters of, and there's obviously a sense in which that's an important part of the tradition. But the way I've come to think of it on the basis of this experience is the sort of atomic particles of freedom are people's readiness to speak rather than not speak, to publish rather than to not publish. And that quality rests on another kind of underpinning than just the law. And I think our ability to sort of generate together by supporting one another in these situations, a kind of civic courage and confidence and sense of vocation under the First Amendment feels really critical because, with whatever, we're sort of entering the dark ages in some ways with respect to the legal. We're in it, but we're going deeper into it in terms of the likely legal formulations. But there's a robust, and as the dean said this morning, the truth is the history of the First Amendment at the level of the federal judiciary and the Supreme Court is mostly really depressing if you know it, and the with fluctuations, with periods of great judicial clarity, but then it can be swallowed by the next era of national security panic and such, and that history is an incredible asset. If we understand that what's kept freedom alive in those periods is people insisting on exercising the First Amendment. So, okay. I don't know.
I hate to talk about a story I haven't written yet. It makes me nervous, but in the context of the Me Too Time's Up stuff, we do get blowback from people who say it's enough already, or it's going too far, and I always say you have absolutely no idea how our process is and how high the bar is for us to publish. So someone came to me with a story about a movie, famous movie star. It happened long ago, feels credible, but this was something that was done in great stealth, what this alleged act was. So I quickly realized that I couldn't do it through conventional means. I tried to ask around a little bit, and nobody knew what I was. And I've had a couple like that. Those are very hard. We can't quite get to the end zone with those because if these are, Harvey Weinstein was sloppy. Roy Price was sloppy. John Lasseter was really sloppy too. But there's a couple of you detect that you can see. Somebody shows me emails. Don't delete this immediately. Don't let anybody read this. And you know that they're operating. So I really racked my brain because I felt like I was failing this source who had this. These are very emotional things. I spoke at a thing recently on journal, Pointer thing, and one of the reporters said she'd covered shootings and fires, but the emotional drain of dealing with these traumatized people has been, and they call you evenings, weekends. It's tremendously debilitating and emotional for the reporter too. So I was just racking my brain. How can I not fail this woman who has carried this secret and been tortured? And suddenly I had a thought that it goes to this question, which is, what if we let her tell her story. She's willing to go on the record, and we don't name the guy. And that serves two purposes. I will use it as an exercise in transparency. This is how someone came to me. This is how we discussed it internally. This is the conclusion we came to. We can't name him. And I asked her, and she thought it over, and she said, I'll do it. I'll do it because I'd rather have it, she gets to tell her story and talk about her process. I get to talk about our process. And that transparency, I think, is going to be, and the final benefit would be, if anybody reads this,
other people might come forward.
we might find that somebody recognizes. Now, and of course, we're going to go to great lengths to not identify. The only people who know who the alleged perpetrator of this is are me and the editor of the magazine, and that's it. And I'm sure the lawyers will have a look, but I think we can do this, and I think it serves a purpose to say, we're not just publishing willy-nilly about people, we are going through a lot of procedures and reviews. So that is my idea that I had to try to, now I've cursed myself by talking about a thing I haven't written yet, but pray for me.
No, I think that gives, what that does is it acknowledges the current time that we are operating in. But I think it also underscores the importance of the story, in the telling. And that this is not to just lob grenades.
I mean, it's a weird thing to do, but it's not a bad thing to do.
But even if we weren't in this time, I think if I understood the Trust Project, trajectory before, nobody knows what journalists do in terms of, what due diligence means, what best practices are in journalism. People simply don't know. When they get close to it, they're amazed. The seemingly disproportionate effort that goes into first reporting and then vetting a consequential investigative story. I do think we need to lift that into more visibility.
So we have time for just a couple of questions. So why don't you make your way to microphones? And while we do this, I wonder, Katie, if you could talk about, are you giving reporters different advice post-Gawker? Are there other, things that you are suggesting to people in order to be better prepared to defend against the wealthy weaponized litigation strategy? Or is it the same?
So the short answer is no. I think that, Donna, as one of the things that you examine whenever you're vetting a story or looking at a story is who is likely to sue and how likely are they to sue. So I think that kind of analysis is always the same. You're always looking at that as a potential factor. And whenever you're sort of reviewing a story or vetting a story on the pre-publication side, it's never about eliminating risk. You can never eliminate your risk. It's always about reducing the risk of being sued if you can, and then certainly doing your absolute best to reduce the liability, reduce the risk of being successfully sued, right? Because there are often times where you might have a story that is terrific, perfect, bulletproof, and you'll still be sued because someone wants to sue you. So that's always something I try to explain to any reporter that we're talking with. So I think this goes back to the prior question that you just asked. I think there is a relationship between the way stories are vetted on a pre-publication basis, as well as the discussion that everyone's having now about credibility, and I bore using the term fake news as well, but the sort of the trust in journalists. And I think I've heard from a number of in-house lawyers at news organizations that I know that they're very focused not just on sort of first principles of the reporters are getting the stories right, they're getting just the most minute detail right. Is this tablecloth blue or was it purple? What color was the tablecloth? That type of thing. But really, not just because it's good journalism, but also because because there may be potential liability issues tied to getting things wrong. But they also want to, I think, in this moment, make sure that that the credibility of that journalism isn't called into question for something that's not substantively important, one of these small issues. And I think that
the smaller details matter more than ever.
They do. They matter more than ever.
Do we have a question? No? You have no questions about going to jail? Okay. I'm thrilled.
Hi. I'm Claire Martin. I'm a freelance journalist, and I teach investigative reporting at UCLA. And I have a question about indemnification for freelancers specifically. And Kim, I think you mentioned you got indemnification from the publication that then didn't publish your piece. I'm wondering sort of what that process was like. Was it hard to get them to agree to it? And Jamie, did you try to get indemnification from Slate? Was that something that you tried to do? And then Katie, do you have any advice for freelancers in terms of indemnification? Because I've noticed that it's increasingly difficult. Contracts more often than not require the freelancer to indemnify the publication.
That's right, the
trend is that
right.
in that direction, and so I'm just want to hear all of your thoughts
Right.
on that.
I asked at 2 different publications. One of them balked, the other was the information. They vet the living hell out of the thing and asked me over and over again whether I asked the guy for money. I mean, at one point I said, we're moving from, I know you have to ask, into you're insulting me. But once they vetted, they did not, there was no pushback. They both agreed.
Did they ask you to indemnify them?
No, I mean, it said in the contract, if you have done something egregiously terrible, you're on your own, but I didn't, so.
Yeah, and that was the sort of contractual agreement I had on the Slate story, which was, there was no real expectation of, or fear of legal pushback at that point. But on other, stories where there were serious concerns of legal exposure, that was the arrangement.
And I would start off by saying that every organization is different. So in other words, there may be organizations that don't or will tell you we do not offer indemnification, and this is our standard agreement. And if you don't want to sign with us, then we won't take your piece. There are other organizations who are completely different. They take a different approach. So my advice is always to freelance and independent journalists. We don't advise on contract issues, but my advice is always, read the contract, understand what you're getting into. If you're not comfortable, particularly in the context of a very risky story, I mean, some of this might depend on the kind of story you're doing, but if you're not comfortable, certainly ask for changes. If you can't get changes to the contract that make you feel comfortable, consider going to someplace else, because like I said, I think that organizations are different. They vary significantly. There's no one approach to this. So I think it's really important for people to understand what the contract provides, what kind of protections they have, what kind of protections they don't have, and to the extent they feel extremely vulnerable that it's not sufficient protection, that they look somewhere else.
Read your deals. Okay, thank you to all of you.